Good morning.
Good morning, Mr. President, members of the board.
Okay. Before you get started, you can go ahead and start. And Ms. Calhoun, she wanted to call in and be on the phone, and they're trying to get her on the phone now.
Good morning again, Mr. President, members of the board. I stand before you this morning. You may recall we had an item on the agenda 2 weeks ago, and the board attorney asked for additional time to review that item. So we at this time we put back on the agenda.
Okay.
Good morning, Ms. Calhoun. We're at the Election Commission item on the agenda for today's meeting.
Thank you.
Okay.
Okay, I'm sorry. Pursuant to the Mississippi Code of 1972 as amended, Section 2315-213, where the Chancery Clerk is required to list the candidates for Election Commission for the upcoming election. You should have before you, if you don't, I've reprinted some of the list of all the candidates who qualified in the Circuit Clerk's office. And they are Marilyn Avery, who is the incumbent for District 1, James A. Reed for District 1, Prima Wheeler, District 1, Josephine Anderson, District 2, Bobby Graves, District 2, Jamal Clark, District 3, Centauri Bracey, District 3, Connie Cochran, District 4, Wheeler Gaston Road, District 5, Blonda Matt, District 5, and Kathy Sachs, District 5. You would also notice that on your list of candidates, all the candidates qualified, met the requirements in the Circuit Clerk's office. Only candidates Bobby Grave and Blondie Matt did not submit that information timely in the clerk's office. So we would ask you this time to make a decision as to whether or not all candidates will be qualified.
Okay.
Pursuant to Mississippi Code.
Okay. Before we go directly to that, I'd like to defer for a second to the board attorney to see if there's any additional information that you want to bring to the board as it relates to this particular issue.
I was asked to review this issue, and what I have found that Statute 2315-213 governs how county commissioners must qualify. And the relevant statute with respect to Ms. Mack and Ms. Graves would be candidates for county election commissioner shall qualify by filing with the clerk of the Board of Supervisors of their respective counties a petition personally signed by not less than 50 qualified electors of the supervisor's district in which they reside, requesting that they be a candidate by 5 p.m., not later than the first Monday in June of the year in which the election occurs, and unless the petition is filed within the required time, their names shall not be placed upon the ballot. I have found no Supreme Court case interpreting this statute and the particular circumstance that we have here. However, I was able to locate 2 circuit court opinions, one from Simpson County and one from Washington County, where similar situation occurred, where there was a timely filing in the circuit clerk office, but it was untimely within the Chancery Clerk's office. And in both opinions, the circuit court said that there should be a substantial compliance standard applied to this particular statute and not a mandatory compliance. Therefore, at least in these particular cases, the potential candidates were allowed on the ballot and the people were permitted to choose or elect the county commissioner. Because there is no Supreme Court case interpreting this statute, I have prepared a letter to submit to the Attorney General's office if it's the board's desire to have this issue upon review by the AG's office. And I guess that would be the end of my report unless there are specific questions.
Okay. Mr. Fisher.
My understanding was we delayed it 2 weeks so that you could contact AG's office and have an opinion from them today.
Well, as you know, many written opinions take much longer than 2 weeks. And I believe the language of the statute is clear and everyone agrees that there is no interpretation from the Supreme Court So a lot of what you're deciding today is within the board's discretion.
So you're saying it's within the board's discretion to determine whether someone who's filed late should be allowed on the ballot. Is that the bottom line?
It's within the board's discretion whether to apply a substantial compliance standard with regard to interpretation of the statute, yes.
The statute specifically says a date and time.
It does.
And so any time after that would be late.
This board is within its power to interpret the statute as such.
Well, it just seems to me that if one day is okay to be late, then why not 5 days or 10 days or 20 days?
And that again is a decision for this board to decide.
Okay.
Mr. President.
Mr. Stubbs?
Mr. President, I make a motion that we open it up to everyone to have an opportunity to file. I think the issue now turn to whether or not we're going to follow the law. And I understand that the issue of whether I filed at one place versus filing another place has created that problem. But I know Ms. Pittman, she also tried to get on the ballot. And she had names, some of them scratched through because people tell you they're registered to vote, but they're not. So I think the best thing to do would be a win-win for everyone. Let's open up for everybody. And I so move.
Okay.
Okay.
Okay,
I would like to make a comment if the motion is second.
Okay, go ahead.
Hello?
Go ahead.
Go ahead, Ms.
Okay,
Kelly.
if I understand Supervisor Stokes' comment, and I couldn't really hear all of them, but I'm thinking that he is saying to include that the certification information or the application information for both Ms. Mack and Mrs. Graves. Is that what you're saying, Supervisor Stokes?
I'm saying let's open up the time period where the qualification time would not be allowed for everyone who wants to qualify. You had some.
You say everyone is not allowed?
Some was disqualified because they said they didn't have enough names.
You said they disqualified Ms. Mack and Ms. Graves?
No, what he's saying, I think you can probably hear me better, is he's saying that he was making a motion to open it up for everyone that wanted to be included in this particular election cycle.
Okay. And that would include those candidates that missed certifying in the Chancery Clerk's office.
Yes, it would.
It would, okay. I'll go ahead and second this motion, and let me tell you why. Generally, the Circuit Clerk's office is very helpful when the candidates they are very helpful, but when the candidates' applications were submitted to the Circuit Clerk's office, I am concerned the Circuit Clerk's office received the information as though it was that office's responsibility to accept the application. So that's my concern. The other concern I have is the voters of the district or the qualified electors of those districts express their concern to have the candidates certified by signing the petitions. Now, my question is, particularly in Ms. Mack's situation, and all due respect to the election commissioners and the circuit clerk, but my question is, if Ms. Mack's application was turned in early on in the year, what happened to the certification information? Why was the information held in the circuit clerk's office? and I think, again, my question is one of fairness and the process. I'm not favoring any one candidate over another candidate. But generally, the circuit clerk's office, as I said earlier, is very helpful. And they try to guide citizens through the process. And I'm not putting any blame, but it's just a question to me, why was the information held?
Okay.
Or what happened to the information? Was it passed on to another office? That's my question.
Okay. It's been moved and properly second. Any other additional discussion?
Can we get a point of clarification for the clerk's office? Mr. Stokes, is your motion then is to open up the election for anybody who wants to run, whether they qualified by the deadline in the circuit clerk's office, in the circuit clerk's office or not?
Absolutely, especially with the issue of you have people like Ms. Pittman who had names, and they had more than 50 names, but then some of them were scratched through. And then at that point, she would say, you don't have enough names. So it wouldn't be fair to tell her that, well, we're going to let others get on, but we're not going to let you get on. She should have the same opportunity to everybody. Everybody should have the equal playing field.
Okay, let me go to Mr. Fisher, and then we'll go back to Ms. Calhoun. Mr. Fisher.
Okay, now what is the matter concerning Mrs. Pittman?
Just hold 1 second, Mr. Fisher, and then we'll go back with Mrs. Calhoun. We'll answer your question at that point. Mr. Fisher.
I'd like to hear from the elections commissioners who are here, who are handling this matter a little bit. It's my understanding that no one turned anything in early. Everyone turned in something late. And that to consider someone who turns in an application for election, particularly an elections commissioner, who's supposed to know all the rules and regulations of an election. If the elections commissioners themselves don't know when they're supposed to turn things in, what does that say for their ability to handle the job if they were elected? And I understand the period to turn something in began the 1st of January and ran until the date designated here today, so there was ample time to turn something in. As a candidate myself, on a number of occasions, I never turned something in and just hope for the best. I, as a matter of fact, checked the afternoon of the final day to see if everything's still okay with my application to assure that we don't have any issues. So I guess, Ms. Carr, I don't know if you can answer this question or if we need to bring the circuit clerk in, but were these applications turned in after the 5 o'clock deadline?
Yes, sir. For the record, all the candidates turned in their application, their packets to the Chancery Clerk's office on or before 5 p.m. on the filing deadline date, except Ms. Bobby Gray, Election Commissioner for District 2, who turned hers in on the morning of June 5th, and Ms. Matt. But also for the record, both candidates qualified in the Circuit Clerk's office in a timely manner. The Circuit Clerk's office certified, they had their appropriate signatures, they did everything that they were supposed to do except Valentine in the Chancery Clerk's office. And that's what's before you today.
Now, to go to the other point about the
signatures. Just 1 second, Ms. Calhoun. Mr. Fisher's finishing up, and then we'll go directly to you.
To go to the point about the signatures, all signatures have to be validated as being residents of that district.
Yes, sir.
Any crossed out, and there are a number of ways they can be crossed out, but any that are crossed out are done so for specific reasons. For example, you can't sign a petition, Mr. Bob Jones and Mrs. Bob Jones. It has to be Mr. Bob Jones and Mrs. Jane Jones. They have to live in the district. So just because you get 50 names and some of them get crossed off doesn't mean anything bad's going on. It just simply means that the job has been done to assure that these names are legal, or that they are the legal names, and that they're legal, and also that they live in that district. Is that correct?
Yes, sir. That's my knowledge. And again, Ms. Mack qualified back in January, so she had all the appropriate signatures. She did everything that she was supposed to do, except she just did not file. And Ms. Mack is here. Her explanation to me was no one told her in the Circuit Clerk's office that she also needed to file just for record in the Chancery Clerk's office. Because that's all that happens. They file for record in the Chancery Clerk's office.
Okay. Again, it's the candidate's responsibility to know these things.
Yes, sir. I'm well aware of that. I'm just giving you all the background information that I have at this point so that you all can make make your decision.
Ms. Calhoun?
Okay, it's my understanding that also Mrs. Graves turned her information in a timely manner. However, that information was submitted to the circuit clerk's office. Now, Mrs. Pittman's name came up. I'm not familiar with her situation. What happens in her situation, please? Can someone tell me?
Yes,
If Mrs. Pittman is there, can she inform me?
I want to get Mr. Stokes to do that. Mr. Stokes?
Thank you, Mr. President. And Ms. Pittman is here. Ms. Pittman, could you come forward, please? I didn't know what you did when I first started. Ms. Pittman was trying to qualify, come to the microphone now, for election commissioner, District 1.
And she had names, and she had over 50-some names, but some of them were scratched through because they're not registered voters, evidently, for District 1. And she was trying to be a candidate, and my position is, since we're finding some errors, whether they are intentional or non-intentional, to make sure that everything is fair for everybody. If Ms. Pittman was only a few names short, let's open the process for everybody.
Okay. What we'll do is...
Are you saying that Mrs. Pittman did not have the necessary 50 signatures?
She had over 50, but some were scratched. Ms. Pittman, can you tell?
Yes. Excuse me. I had 57 signatures. One, she said that she could not read whoever the person's name was. A couple were in District 2, and a couple were not registered voters. So I didn't pursue it any further. However, if you open it back up, I will. But and I did not know then that after that I did not have the required amount, that I still could submit it to the circuit Chancellor Clerk's office.
So you were not notified that all of your signatures were not proper?
I was notified the morning after the deadline. However, I did submit it prior to that, but it was near closing time, so they told me to come back that morning at 8 o'clock, and when I got back the following morning, she had already gone through them and had disqualified some of the signers on the signature.
Okay.
Had they done that when I submitted them before the deadline that last day, then I could have had time to go back and get the few that I needed, because I didn't get anybody on my street, you know. So that was it. So
Okay, thank you very much. One of the things.
One other question, Supervisor Stokes.
Yes, ma'am.
When you say open the process back up for everybody, are you referring only to those three persons, or are you saying open the process back up for all of Hinds County?
Well, I don't know
all the people or any individuals in Hinds County that live in those respective districts.
Well, I don't know if we could limit just to those three. I think that we already in a gray area. If you limit those, just only those three.
What you're saying is open.
You got to open up to everybody.
Are you saying allow just those three individuals?
No, you probably have to
When
allow
I think in
everyone.
your motion, I assume that you are only referring to those individuals that attempted to qualify and be certified.
Okay. What we'll do is we'll have Mr. Stokes.
But are you saying you just talked about the three individuals? Is that correct?
Can you hear me, Ms. Calhoun?
No, I can't hear him.
Okay, I'm going to speak and see if you can hear me. He's stating that he thought that, to be fair, that it should be opened back up to everyone in the entire election process, that he didn't know if it was just limited to those three individuals or that wanted to be on this particular ballot. That was part of his motion. What I'm planning on doing, unless you have a follow-up question, is I want to try to keep this moving forward. I want to make sure that we are as fair as possible, and that is to allow, complete Mr. Fisher's request, and that is to allow all of the individuals involved, the election commissioners, if they want to have an opportunity to speak on this particular issue, to allow everyone an opportunity to speak. So do you have a follow-up question to that? Ms. Gallagher?
I'm sorry, what did you ask?
Do you have another question that you want to ask at this time?
Yes, I would like the attorney to address opening the process back up to everyone in Hinds County.
Okay.
Truly opening up the process to everyone does cause me concern. You do have 3 individuals, it appears, where there were irregularities perhaps made. So there seems to be perhaps some factual basis within which to consider the 3 that have been presented before the board. However, we don't know of any basis to open it up, and I'm not sure that the board has authority to formally extend the deadline without any other proof.
Okay. All right. Thank you very much.
Okay, then I will have to withdraw my second. I'm willing to work with, and since there's a third name added, I'm willing to work with those 3 individuals. Because it appears again that they did submit information in a timely manner. However, because of submitting the information to the wrong office or not being notified that some of the information that was submitted was improper, I have no problem, Supervisor Stokes, with seconding a motion to that regard, but opening the process back up to all of Hinds County, I have a grave concern about, excuse me, I have a serious, I don't want to infer anything other than, I have a serious concern. I would have a serious concern about opening the process to everyone in Hinds County.
Okay. We will continue to move on. Thank you very much, Ms. Pittman.
And Supervisor Stokes, I hope that you would reconsider or withdraw your motion and reconsider.
Okay. We have several of the election commissioners here. Would either one of you like to speak on this particular issue?
Mr. President, while they're coming forward, I want to remind the board again, all candidates on the list that I submitted to you followed the process, went to the circuit clerk's office, all their signatures were verified, they were stamped and filed in the circuit clerk's office in a timely manner. They just were not the only 2 candidates that just did not file with us in the timely manner. Were Ms. Gray, all of her signatures were verified, she followed the process, everything was complete.
Right.
Same was with Ms. Mack. They just did not file timely with the Chancery Clerk's office. I wanted to make sure that everybody understood where we were coming from. Your list was certified to us. Everything was brought to us, stamped out by the Circuit Clerk's office, and each one of the candidates brought their own information, not the Circuit Clerk.
Thank you. Okay. Good morning, Mrs. Graves.
Oh, wait, just before we start, when I talk about elections commissioners, let me rephrase that. I think we should have only elections commissioners in non-contested races.
No.
I think to have an election commissioner come up and speak against or for what we're going to do, but a contested race would be prejudicial.
Well, my thinking behind that is that Mrs. Graves had contacted Mrs. Davis and had requested to be on the agenda prior to this.
But she's not an elections commissioner.
Okay.
I'm speaking specifically of an elections commissioner. There's only one that's unopposed, and that's Ms. Cochran. The others, I think, would be prejudicial for them to come up and speak because, well, you know,
I'm going to allow
a great chance to.
I'm going to allow all of them to speak, and that way I know that I'm being fair by allowing any and everyone as it relates to this particular issue to speak, and that way we'll know that we're ensuring fairness. Good morning.
Good morning, Mr. President. Good morning, Board of Supervisors. At this time, I would like to refer my comments to my attorney Warren Martin.
Okay.
Mr. President, board members, good morning.
Good morning.
There's been a significant amount of discussion with regard to the statute, Mississippi Code annotated 23-15-213. The board attorney has brought to the board's attention the two cases, which is my understanding were not appealed to the Mississippi Supreme Court, so we don't have a Mississippi Supreme Court ruling with regard to those issues. But I wanted to share something that trumps the statute and that will potentially trump a Mississippi Supreme Court opinion, and that is the Mississippi Constitution. Article 6 of the Mississippi Constitution of 1890, Section 157, reads, and I quote in your hearing, "All causes that may be brought in the circuit court whereof the Chancery Court has exclusive jurisdiction shall be transferred to the Chancery Court." Now, the one thing that Madam Clerk just brought out, especially with regard to my client and with regard to Ms. Mack, both petitions were timely filed with the circuit clerk's office. So to disallow them an opportunity to be placed on the ballot, Mr. Stokes, would in effect terminate their petitions. Under the Constitution, Article 6, Section 157 says you don't terminate them. The role of the circuit clerk is to transfer them to the Chancery Clerk's office. So I would submit to the board, little credence should be placed on the statute, more credence should be placed on the Constitution. I've submitted this to the board attorney in a letter, along with my noting my representation of Ms. Graves. I would note that there will be significant legal implications if my client, Ms. Mack, are not allowed to be placed on the ballot.
Okay. Thank you very much. Are there any other election commissioners here present that would like to speak regarding this particular issue?
Could we get a copy of that, Mr. President?
Ms. Cochran. Good morning, Ms. Cochran.
Good morning.
I'd just like to say that everything that goes on in the election process is governed by statute. We don't have the right to do it this way or that way. We have a law that we have to abide by. And I would also like to ask Mrs. Graves where she qualified 4 years ago. Now, if she didn't know 4 years ago that she had to go to the Chancery building, then she's had time to learn that. The statute is so very clear. 5 o'clock, June 4th. And it specifically says, in the Chancery Clerk's office. It doesn't say that years ago, it used to be that we did qualify in the Circuit Clerk's office. It is the responsibility of any candidate to know what the qualification process is. And I really feel as though if you are usurping the law if you vote to allow this to go on. It clearly states that you have to have 50 qualified signatures. Therefore, you go out and get 75 or 100 to make sure that you have 50 qualified signatures. There's not a gray area here. It is black and white. Thank you.
Okay. Any other elected officials that would like Mr. Clark would like to speak to this issue?
Yes, sir. Good morning.
Good morning.
President, Board of Supervisors, audience. I'd like to call your attention to statute 2315-211. 2315-211 gives the Board of Supervisors latitude to vacate a commissioner serving a sitting commissioner's office if he or she fails to turn in their certificate of certification of training. So, and keeping with the Supreme Court decision and the information that the attorney brought forward to the board concerning the decision or non-decision or statute, I submit to you that if the 2315-211 allows and gives the Board of Supervisors in each of the 82 counties in Mississippi the latitude and longitude and authority to vacate any one of the 5 commissioners' positions based on the fact that they did not turn in a certificate of training within 30 days or by April 30th within the year of which they received training. So that gives you, in my opinion, some latitude to make a decision by this board to include or not to include.
Okay, thank you very much. Any other elected official election commissioner? Mr. Stokes.
Thank you, Mr. President. Mr. President, I lost my second on the motion I made, but it's clear from everyone speaking, the attorney from Ms. Gray saying that following the Constitution, that we will have legal problems if we don't put Ms. Graves, and I'm not saying the other young lady because he represents Ms. Graves on the ballot. All right. The circuit clerk, the election commissioner stated that it's all by statute. And even though they're throwing rocks, so to speak, in terms of criticism, they should know, a lot of things. I'd rather not get into those criticisms, but her position is by statute. She should have known the statute. Now, the only win in this, Mr. President, is to open up for everybody. That's the only way, because you heard the election commissioner say that, Pat Chapman, that everybody knows what the law is. You heard the attorney from Ms. Gray say the Constitution should dictate, and it's saying that they should be able to be on the ballot. Now, do you make a choice between those two people, or do you open it up for everybody? My position is open it up for everybody. And even though I don't have a side seat, that's how I'm voting. Thank you.
Okay.
Mr. President, I would like for our board attorney to interpret the statute that Commissioner Clark just referred to. I couldn't really hear everything, so if the board attorney could give her interpretation.
Ms. Calhoun, I did hear what Commissioner Clark said. However, I was not anticipating an interpretation of that particular statute. But from what I understand, Commissioner Clark to be stating is that Section 2315-211 gives the board the authority to vacate the office of election commissioner if he or she fails to turn in a certificate of training within a certain time period.
If he or she what?
Fails to turn in a certificate of training within a certain statutory time period.
Are you at the microphone?
Yes, she is at her desk, ma'am.
Okay. I can hear you better.
She stated that 2211 states that the Board of Supervisors has the authority to vacate a commissioner's position if they fail to turn in their certificate of training within a certain time period.
Okay.
Certificate of training.
Correct.
And it doesn't say certification information. If I'm interpreting what is being said.
It's the certification.
Certificate of training. It has nothing to do with the certification process.
I believe it's related.
Okay.
I'm sorry, what was it again? And thank you all for being so patient, trying to help me here. Understand.
From what I understand, there is a certification of training that each election commissioner must complete. So it's a certification for training.
Certification of training, that is not the same as certification of qualification. Is that correct?
Correct.
Okay.
Okay. We've had plenty of discussion on this. What we'll do is we'll go back to Mr. Stokes, who made the original motion.
I would like to make Mr. Stokes, Supervisor Stokes, I would like to make a motion for consideration.
Okay? If that's,
Supervisor Graham.
in other words, you want to amend the original motion?
Well, I withdrew my second.
Okay.
No second.
Okay, so there's no second, so you'd like to make an additional motion?
I would like to make a motion.
Okay, go ahead, please.
Okay, my motion is to allow Ms. Graves, Mrs. Graves, Mrs. Pittman, to be certified based on the fact that all information was turned in a timely manner to the circuit clerk's office.
Okay, is there a second?
So my motion is to allow those individuals to be placed on the ballot for the upcoming election.
Okay, is there a second?
Mr. President, I'm a second for discussion.
Seconded and discussion for Mr. Stokes.
Thank you. Supervisor Calhoun, Ms. Pittman did not have enough signatures. That's why the only way she can get on the ballot, you have to open the whole process up. She did not have enough signatures.
The reason I say I was including Mrs. Pittman. She was not notified that the information provided to the circuit clerk's office was not proper. All of the information was not, I use the word proper.
Okay.
So I did include Mrs. Pittman.
Okay, it's been moved and properly seconded.
Mr. President, I just seconded for discussion purposes. I'm going to withdraw my second.
Okay. It's been moved. Is there a second? Is there a second? I will second it. It's been moved and properly seconded. All those in favor of?
Wait, hold on just a second. I have
Excuse me.
now this motion is to allow the three people who didn't meet the qualification deadline. One of them is the elected official who's been enforcing the election laws for all these years, to actually be put on the ballot despite the fact that they did not meet the deadline.
Does that meet your, is that what your statute, or excuse me, your motion completes, Ms. Callan?
No, and that is not, as far as the certification deadline, the individuals did submit their application in a timely manner. However, they submitted the information to the wrong office.
Okay.
So, and without me being an attorney, I think that the information should have been forwarded to the correct office. Or my question is, why did the circuit clerk's office hold that information?
Okay. We have a motion and a second, and we have additional discussion by Mr. Fisher.
So to be clear, Ms. Calhoun, your issue with the circuit clerk and whether or not they passed, the chancery clerk, and whether or not the information was passed from one clerk to the other, justifies in your mind this board ignoring the state statutes on laws. Is that correct?
I think there is additional law that would substantiate the motion that I made. And I think Mrs. Graves' attorney just provided you with the law from the Mississippi Constitution, which I was not aware of. However, I do, and I'm not putting any blame on the Chancery Clerk's office. However, I do feel that when the candidates' applications were submitted to the circuit clerk's office, the information was received by that office as though it was the office's responsibility to accept the application.
Okay.
I have that concern.
All right, let me finish up. We've been on this issue now for an hour.
May I say something for the record, Mr. President?
Okay, just 1 second, please. We have been on this issue for an hour. I'm going to allow each individual that's involved in this particular issue to make another statement, and then we have a motion, we have a second, and then we will commence to vote, starting with the Chancery Clerk.
I just want to clarify for the record that the Chancery Clerk's responsibility in this process is simply to file once received. That is all that we do by statute.
Thank you very much. We'll now go to Mr. Stokes. Do you have
we understand you dutifully upheld your responsibility.
Yes,
we
ma'am.
all understand that.
Okay, Ms. Calhoun, we'll just hold 1 second, please. We're going to go through each supervisor, and then we'll come back to you. We'll start with Mr. Stokes.
Thank you,
If he
Mr.
has
President.
anything additional to say, then we'll vote.
I do. Mr. President, again, my support and my focus is to open up for everyone. And, truly I understand that the motion that we have on the floor is for 3. But we all know that if it's challenging the court of law, that they're going to throw Ms. Pittman out because she does not have the required 50 names. But if we open it up for everyone, she has an opportunity to get those 50 names. She had, that time, if they had checked her names that day and told her she needed, whether it was 3 or 4 names, because she had 50,000, then she would have got those names. Now, we got to be fair to everyone. And the only way we can be fair to everyone is open it up to everyone. And even though we're saying we're going to put the 3 names today in the challenge, Ms. Pittman is completely going to be off because she did not even have a 50 names. So I'm staying with Ms. Pittman, and that's how I'm going to vote. Thank you.
Okay, Mr. Fisher.
So I think Ms. Pittman would have a legal chance to be considered a valid candidate.
Not with that 50
simply
names.
because she was not notified that her signatures were improper.
Okay.
So she would until after the close of the election. So I think she would be standing on good grounds.
Okay.
And even though Attorney Martin is not her attorney, and he's Mrs. Gray's attorney, Attorney Martin, can you answer that question?
Okay, we're getting ready to vote, Ms. Gale. I'm going to let every supervisor talk and speak to this issue one last time. When I get to you, if you want him to speak to that issue, then we'll speak to that issue. We'll go to Mr. Fisher and then to Ms. Calhoun, Mr. Anderson, and then we'll be finished with this particular issue. Mr. Fisher.
This whole discussion and this whole idea of adjusting and changing dates of when you can qualify and when you can is disgraceful. Usurpation of the laws is stated plainly and simply. And the vote on this today, I think, is a slap in the face of a system that we should all respect and that many have spent many years of their life defending in one way or the other. For anyone to say that you can file after the fact opens every election now to that very same standard. This board sets a precedent that you can come back if you want to run in 3 years for supervisor or sheriff or tax collector. What's the big deal? Why even worry about the election deadline? Just wait a couple of days afterwards. Think it through a little bit more. Then go file. And this board has set a precedent now where it has to let you go forward. And it's setting a precedent based on an attorney opinion of a Mississippi Constitution statute that has no play in this, and it should be, I think, tested in a court. And it's my hope, Mr. Martin, is that correct? Your name, Mr. Martin?
Yes, sir, it is.
I hope you have that opportunity to correct it in court. And I'd like to ask, are you related to anybody here in the room?
Let's try to keep the comments to the issue.
Are you related to anybody here in the room?
Let's keep the comments to the issue.
But it's Miss Martin's brother-in-law.
Okay, let's
I think we need to note that too. If we continue down into this trap and y'all ignore and completely kick to the curb the election laws of the state.
Okay, that will be noted. That will be noted in the record. We will now ask Mr. Anderson, do you have any comments that you want to make on this? Okay. Thank you very much, Mr. Anderson. We'll now ask Thanks, Ms. Calhoun.
Aye.
Do you have any additional comments that you want to make?
Ms. Calhoun, do you have any more comments?
No, but what was the vote?
No, we're
There's
just
no
getting ready to vote.
Oh, okay.
Okay, all those, we have enough comments, and all those in favor of? Opposed to?
Vote is aye. Whenever you get ready to vote, let me know, because I'm voting for.
Okay.
Okay.
We got that, Ms.
Well,
Calhoun.
restate the motion. It's the motion that you made, Ms. Calhoun.
The motion is to allow Bobby Gregg, Blondie Mack, and Ms. Pittman to be certified based on the fact that the info was turned in a timely manner with the circuit clerk's office.
Okay, all those in favor of?
And Supervisor Stokes, let me say this. Some 21 years ago, the election commissioners did not certify me as a candidate for the Board of Supervisors. The certification process that they used was, well, anyway,
Let's get on, we get ready to.
overturned. The circuit clerk ruled, not the circuit clerk, the circuit court ruled that I should have been certified. And we went to and the circuit court's ruling was appealed. And we went to the Supreme Court, and twice the Supreme Court ruled that I should have been certified. So sometimes, and the rules and regulations that the commissioners were using were overturned by the courts as being illegal.
Okay.
And Supervisor Stokes, I feel confident that Mrs. Pittman has a fair chance in not being disqualified.
Ms. Calhoun, I hate to interrupt you, but I'm going to close discussion on this particular issue, and we now time to vote. All those in favor of?
Aye.
Opposed to?
No.
Motion fails.
Mr. President.
Please read the order.
Mr. Anderson?
You read it.
Right. There is no order, but I just want to make sure that you record the votes in the proper way. And then we'll go to Mr. Stokes and then to Mr. Fisher, and then after this, we're going to move on to the regular agenda. Okay, Mr. Stokes.
Mr. President, I just want the record to show that Mrs. Martin, the attorney for the board, has no bias. And I know sometimes in these things come up about relationships and family. I was traveling and talked to her a couple of times, and she gave me every facet of the law. She didn't try to sway me this way or that way. And sometimes, we can say these kind of things and it make people think that it's some shenanigans taking place when it's not. So I want the record to show there's no shenanigans.
Thank you. Thank you very much, Mr.
So for the record, the motion failed.
For the record, the motion failed.
And thank you, Mr. Stokes.
I have a motion.
Stating the truth.
I have a motion in this matter. That motion is that the Board of Supervisors certify the list as presented by Ms. Carr, stating the candidates for the race, those that qualified and those that did not qualify.
It's been moved. Is there a second? It's been moved and properly second. All those in favor of?
Aye.
Opposed to?
No.
No.
Motion fails.
Madam Attorney,
Yes, sir. What was
please advise
that?
us on this, because we have, the candidates have to know one way or the other.
Let me,
I'm sorry. What was the motion?
Ms. Calhoun, the motion was to certify the election commissioners that qualified timely to the election commission, and then those that did not, to not certify.
Okay. And then motion
I will
fails.
have to abstain on that motion, because I think those that certified in a timely manner should be certified, and those others did certify in a timely manner. It's just they did not certify in the correct office. So I will abstain on that one.
Okay, let me make sure this before you go any further.
She voted nay.
Okay. She voted.
No, she abstained.
I didn't really hear it, so that's why I asked for clarification, because I thought something else was said. And then when I heard the vote, then I said, well, apparently I misunderstood.
Okay, the vote is
my vote will be to abstain.
The vote is 2 for, 2 against, and 1 abstention. The motion fails. Okay? All right, now we will continue. I'll get with the attorney, Ms. Carl. I know what your thoughts are, and we may have to take a recess during this particular session, but I want to move on and allow the attorney, for you and the attorney, to see which actions we should take from this particular point, and then we'll go as we receive information from the board attorney. But that's the issue.
Thank you, Mr. President.
Thank you very much. We will continue with the agenda, and the agenda will now go from there to the approval of minutes.
Ms. Calhoun, we're moving on to the minutes. Do you want to remain on the line?
I would like to participate in some of the discussions. So, what's after the minutes? Will we go directly to the claim?
Yes, ma'am.
Okay, could you call me back, please?
You want to be called back when?
You're supposed to terminate and call me back anyway, I think, legally. But just call me back when you get to the supervisor's discussion.
Okay, when we get to Mr. Graham's items.
Right,
Okay.
and the other supervisor's items.
Okay, thank you.
Thank you.
Okay, we will continue with our printed agenda with the approval of minutes. Good morning.
Good morning. I have the minutes for June 18, 2012 for your approval.
What's the pleasure of the board?
Move for approval.
It's been moved. Is there a second?